First of all, good morning and welcome to the Palm Desert Virtual Town Hall. This is being hosted by Fair Housing Council of Riverside and Palm Desert. Today's town hall is made possible through the Education and Outreach Initiative under the Fair Housing Initiative Program, funded by the Department of Housing and Urban Development, also known as HUD. So we're pleased this morning to have our panelist from the City of Palm Desert, Councilmember Susan Marie Weber. And I'm going to read this, so bear with me. Susan has a long history of involvement with the Coachella Valley business community dating back to 1972, when she was a co-owner of the Covina Marina, a recreational business on the Salton Sea. No stranger to community involvement, Susan Marie was a board member of the Palm Desert High School Foundation from 1987 to 1994. She is also a past board member of the I'm going to mess this up, the SOAR Fort Miss International, NABO, Friends of Indio Senior Center, and Rotary Club of Palm Desert. She continues to be active in Toastmasters and with Palm Desert Rotary Club, which named her its Rotarian of the Year in 2010. Susan Marie also serves on the board of Historical Society of Palm Desert and provides volunteer notary services to seniors at the Jocelyn Center. Susan, welcome. Our next panelist has been a housing advocate in Southern California for the last 7 years. Carl Wallen started as a volunteer for the Legal Aid Society of San Bernardino and has since become a practicing attorney for Inland County's legal services and has assisted numerous clients with unlawful detainers at all stages of representation. And from Fair Housing Council of Riverside County, we are joined by testing coordinator and fair housing investigator, Richard Lemire. Richard began his career with Fair Housing in 2015 and has held several positions during his tenure. Prior to joining the Fair Housing Council, Richard served as the Senior Public Information Specialist to Community Action Partnership of Riverside County, where he was responsible for all community and media relations. And also as a panelist, we have Mike Nagy, Public Affairs and Riverside Area Manager of the Southern California Rental Housing Association. Mike has been managing and coordinating the SCRHA's advocacy and public affairs activities since 2014. He is responsible for disseminating and communicating information to their members on current events, industry trends, legislative and regulatory issues affecting the rental housing industry. So to all of our panelists, I say welcome. My name is Nathan Szynski. I will be the moderator for this morning, and I'm the program manager for Fair Housing Council of Riverside County. At this time, all attendees are on listen-only mode. We're going to encourage your questions and request that you type them into the Q&A panel, which is located at the bottom of your screen. If you would like the opportunity to ask your question live, simply write the word live followed by your question in the panel, and we will unmute your line. We're going to begin this morning with opening statements from each of our panelists, after which I will be presenting the panelists with questions that the Fair Housing Council has been receiving from the residents of Palm Desert. We will then open the floor to the attendees, and their questions will either be read out loud or you'll be provided the opportunity to speak. I would like to now turn this over to Richard Lemire for his opening remarks.
Thank you, Nathan, and welcome. The Fair Housing Council of Riverside County is a nonprofit housing counseling agency whose primary mission is to prevent discrimination in housing. The Fair Housing Act was signed by President Lyndon Johnson in 1968, 1 week after the assassination of Dr. Martin Luther King. The Fair Housing Act prohibits discrimination in housing based on race, color, national origin, sex, religion, disability, and familial status. These are called protected classes, and the state of California has added an additional set of protected classes that are protected by state law. Fair Housing Council of Riverside County identifies discrimination primarily through the phone calls that we receive. and we receive an average of 60 to 90 calls daily at 3 offices in Riverside County. When discrimination is alleged or uncovered, Fair Housing Council of Riverside County investigates the complaint and then refers it to an enforcement agency, either the Federal Department of Housing and Urban Development, the California Department of Fair Employment and Housing, or a private attorney. Fair Housing Council of Riverside County is not an enforcement agency. The bulk of calls received are for landlord-tenant issues. Fair Housing counselors advise these callers as to their rights and refer them to the appropriate resources when required. There are many occasions when discrimination is identified by the trained counselors. Many times our clients do not even realize that they are being discriminated against. Our agency provides fair housing services to the County of Riverside, as well as 10 cities in the county that receive Community Development Block Grant, or CDBG, directly from HUD. These are called entitlement communities. The city of Palm Desert is one of the entitlement communities that we have contract with. Other services that we provide are first-time homebuyer counseling, as well as one-on-one counseling for homeowners facing foreclosure. Fair Housing Council of Riverside County conducts informal administrative hearings on behalf of the housing authorities of Riverside and San Bernardino counties for Section 8 tenant grievances. And we also provide training and technical assistance, including fair housing training for government, community organizations, and business groups, including realtors who are mandated to complete fair housing education. And through this Fair Housing Initiative Program Private Enforcement Initiative, or FHIP, as Nathan alluded to, Fair Housing Council conducts housing discrimination audits and tests, which result in discrimination cases being referred to HUD, DFEH, or private attorneys. And another component of the FHIP grant is education and outreach. These town hall meetings are being conducted under the auspices of the FHIP grant, as well as providing services to our contracted communities. So Fair Housing Council of Riverside County is pleased to have you join us today. And now for the opening statement, Council Member Susan Marie Weber of the City of Palm Desert and a good fellow Rotarian. Welcome, Susan. Yeah. Oh, she's muted.
I see we have our
We do.
correct. I just wanted to say thank you for setting this up. I was able to join this as a last minute fill in for somebody, so I really, really appreciate this opportunity. As you can imagine, housing is extremely important to the city of Palm Desert. In fact, if you drive around the city of Palm Desert, you don't even realize that you're looking at our affordable housing. We're so very proud of how we've set it up. We have 1,100 households in our affordable housing program. We also have a housing commission that's made up of our community volunteers. So in that manner, we try to stay on top of all the issues people are facing. And we, of course, like other cities, we have services and funding to help people who might be having issues, particularly at this time of the year when we're having all these COVID issues. So again, I want to thank all of you for participating in this so that we can educate our public. Palm Desert is well known for the focus on education in our city. We like to make sure that everybody knows everything that's available to them, which we'll be discussing as we go further on. Thank you, Mr. Lemire.
Okay, and at this time, I would like to invite Carl Wallen for his opening remarks.
Thanks for having me. I'm, of course, with Inland Counties Legal Services. Inland Counties Legal Services, or ICLS, as we often go by, is a nonprofit 501c3 corporation which provides legal assistance to low-income individuals, families, and seniors free of charge. ICLS serves San Bernardino and Riverside counties with offices throughout both counties. Of course, you can contact our toll-free number at any time, 1-888-245-4257, to begin the process of receiving assistance. We do have physical locations located in Riverside, San Bernardino, Indio, Victorville, and Rancho Cucamonga at this time. We are, of course, subject to sort of COVID availability, so we can't necessarily have people physically come in at this time, but we're excited to get those open back up once we can. Of course, in order to qualify for our services, because we receive grant funds, we're only allowed to assist those who qualify for our services pursuant to those grants. We do have income eligibility guidelines. There's a threshold income amount that our clients have to make under that amount in order for us to provide assistance to them. In addition, we do have legal status requirements, such as U.S. citizenship requirements, legal permanent residency requirements, or certain exceptions under things like VAWA or the Violence Against Women Act. We do have various levels of services. If you were to call our hotline, if you qualify for our services, you'll likely receive our basic level of service, which is consult and advice. We also do brief services such as document preparation on some issues, as well as on other issues, negotiation with the other party, or even in some cases, representation. That concludes the opening statement for ICLS. Thank you.
Thank you, Carl. Now I'd like to invite Mike Nagy for your opening statements.
Great, thank you. Good morning, everybody. So my name is Mike Nagy. I'm the Public Affairs Manager and the Riverside Area Manager for the Southern California Rental House Association. So we are a 501c3 6 membership trade organization representing companies and individuals in the rental housing sector. And our members include property managers, fee-based managers that handle the operations and maintenance for individual landlords. We have what we refer to as supplier members, who are vendors who provide goods and services to the rental housing businesses and to the industry. And as well as we also represent a good portion of what we refer to as mom and pop independent landlords. And consist about 70% of our membership. And they are independent landlords that maintain and operate their own properties, and they're also typically members who own 15 units or less. Also, a little bit description of our territory. We are basically an affiliate of the National Apartment Association. Our territory covers all of Imperial and San Diego counties, and also as well as portions of Riverside County. Basically, the Southwest Riverside areas of Temecula, Murrieta, going northward towards the southern portions of Moreno Valley, Hemet, San Jacinto, and then our territory goes eastward into the Coachella Valley, Palm Desert, Palm Springs, Coachella, India, what have you. Our organization is basically made up of three major components. Our first component is basically marketing and business development. That's for our members to promote and to promote themselves and their products. We're also an advocacy and a representation organization representing our members in regulatory and legislative issues, also as well as also sharing them information about what is happening within the cities in our territory about issues regarding the rental housing, maybe other things that could affect housing policy. And also we have a strong education component as well, where we have opportunities for workforce development, for classes, and also we refer to as designations. And basically these are certifications for rental housing professionals who want to receive an NAA designation in terms of becoming, let's say, a property manager, or honing their skills and become a certified property manager, leasing agent, even a maintenance technician. And so we conduct classes weekly throughout the year on a variety of rental housing topics, such as fair housing, and maybe providing notices, legislative updates, and as well as also our designation courses that we provide certain times during the year. And then lastly, so information, if you want more information about our association, our web address is www.socalrha.org. Thank you.
Thank you, Mike. And to all of our panelists, I would like to thank you for taking the time today to join us. I know that fitting it into everybody's busy schedule can sometimes be difficult, and I know that the residents of Palm Desert will absolutely appreciate your taking this time. Again, I'd like to remind the attendees on the line that during this presentation, if you have any questions, please enter them into the Q&A chat box at the bottom of your screen. You have the opportunity of requesting the ability to ask your question live simply by typing the word live in front of your question. Those individuals will be taken off mute when we reach that point of today's town hall meeting. I'm going to begin with a fair housing question, which will be directed to Richard Lemire. Richard, since COVID-19 began, have there been any emerging trends in terms of discrimination or disparate impact that have been received by the Fair Housing Council, Riverside County?
Well, yes, there have been some changes from what we've been used to, particularly in the areas of race and in the areas of sex, which is one of the protected classes. And this has been on sexual harassment, particularly in verbal, physical, or visual sexual harassment, possibly brought on by just the fact that people are at home right now and there's more incidents that are reportable. But this has been quite an uptick in these type of cases. We've also seen an increase in discrimination against the physically disabled. For quite a long period of time, mental disability has always been near the top of the list, but now we're seeing more physical disability discrimination complaints. And in particular, in disparate treatment, the victims are women, particularly women of color, low-income females. So yes, there has been a dramatic increase in what we have been seeing and having to deal with, and eventually turning these over for enforcement.
So from the Fair Housing Council Riverside County's point of view, what indications are there or reasons that you believe that there's been an increase in sexual harassment? In regards, particularly how has COVID-19 appeared to affect that?
As I mentioned earlier, just the fact that people are home more, families are home, and there's just more interaction with some of the, unfortunately, people, either property management or of maintenance personnel that have more, maybe feel more emboldened at this time. So, it's an unfortunate situation, but there has been that increase.
All right, thank you, Richard. My next question is for Councilmember Weber. Does the City of Palm Desert have any programs or resources that are in place to help the tenants who are struggling to either pay their rent or catch up on past due rent? You're still muted.
So you're talking about our programs that are in place for people to catch up on rent issues?
Yes, either to catch up on rent if they've fallen behind on any rent, or any resources or programs that are available to the residents in Palm Desert.
Well, our council just recently approved the emergency rental assistance program, as you are aware of, using the $241,000 HUD funds that were authorized by the CARES Act. So we have been authorizing payments up to $5,000 a person to do this, to catch up on their rent issues and so forth. The other thing we try to do is remind people to call 211 if they need assistance and get direction. We also try to advise them on how to get direction. We are using the nonprofit agency Jewish Family Services of the Desert, and they've qualified already 66 households for our program.
What are the requirements to qualify for that program?
Well, as you can imagine, that's kind of confidential information. So as Mr. Lemire said, it's usually based on finances and other private information.
Okay. I guess the main question, without it becoming confidential, this program, they have to have been affected by COVID-19 directly, correct?
Right. And that's why we're using an outside agency to verify all of that information.
Okay, sounds good. And what was the name of the agency again?
Well, the Jewish Family Services is a nonprofit agency that's has already qualified 66 homes already.
Very good. Thank you so much.
Thanks.
If I may, I believe that most of the rental assistance that's available out there is geared to low and moderate income residents. So that
Correct.
is a that's a qualification without getting into confidentiality.
Correct.
So Carl, in terms of protections that are in place, can you go over as briefly as you can in the time that we have allowed,
Sure.
AB 3088 and
Sure.
those protections affect the residents and what they need to do?
Sure thing. AB 3088 is fairly long and fairly complex, but I'll try and point out the things that our viewers are most likely to care about and the things most likely to affect them with the limited time I have. So AB 3088, one of the major things it does is it will affect a stop on evictions for non-payment of rent if you timely submit a declaration of inability to pay to your landlord after receiving a 15-day notice to quit. So I said a lot of legal language. What does that mean? Basically, if you fall behind in your payment of rent between the period of March and September, and your landlord gives you a notice to quit, to pay that money or to leave, you have the ability to submit a declaration that says that you can't pay because you've been impacted by COVID-19. And if you were to submit this within that 15 court day period of time, the landlord would no longer be able to evict you for that money. In addition, if you fell behind in payment of rent between September and January 31st of next year, you would be able to do the same thing, but you would have to keep submitting a declaration every single month that your landlord gave you a 15-day notice to quit. So you basically have pretty strong renter protections for those that are impacted or affected by COVID-19. Please note that you don't actually have to have COVID-19 to submit this declaration. You can just be affected by it. And many people in our community have been affected by it in a number of ways. One of the ways in which you could possibly be affected is by increased childcare costs. Maybe your child's school was closed. Maybe as a direct result, you started to have to pay a lot more than you've ever had to pay before for childcare. And that would be a direct effect of COVID-19, and you'd be able to submit that declaration to your landlord that would avoid the eviction. Please keep in mind that you do still have the obligation to pay 25% of the rent owed, even if you submit this declaration, and that would have to be paid before the end of January. Failure to do that would ultimately result in an eviction beginning in February if you failed to pay. Also, please keep in mind that the landlord can still go after you in civil court, or small claims court, I apologize, for the money that it is owed. While they won't be able to evict you for that money, they're still entitled to it in small claims court, where they could get a judgment against you to try and eventually get that money. Again, not an eviction, but they could still go after a judgment for the money. That's one of the main points that people ask me about in regards to AB 3088. Another big one is that until February of 2021, landlords will require cause to evict. No more giving a 30 or 60-day notice because they feel like it. They need good cause reason now, which is found under the code. I don't know if I have time to explore what those reasons are, but you should know that the landlords now require a cause to evict, and that is in place until February of 2021.
Thank you, Mike. I will have a follow-up question to that, but I'd like to move over to Mike. Mike, in terms of your association, what advice are you giving your members in regards to tenants who aren't able to make their payments? What kind of information are you providing to your association members?
Well, first, what we're trying to do is to make sure that they're establishing communication, that all of our property managers and our landlords are providing or communicating, asking them, are you affected? And I know obviously there's provisions within the law that you have to be careful about how you ask those questions and what questions you use, but basically to reach out to them and say, have you been affected? And then trying to work out a deal or work out an agreement, between both parties, have that document signed about how or what efforts will the tenant be able to, how will they be able to repay and that rent that is owed. So we conduct a lot of classes, and specifically with AB 3088, as well as another law that went into effect earlier this year regarding rental caps, and also just cause regarding AB 1482. And so we've been in our communications and through our courses, and through also we have several counselors online that are guiding them through the process. I'm providing them suggestions of what landlords can do to begin working with your tenants.
Thank you. In terms of resources for property owners or property managers, what resources are available to your knowledge for a property owner or manager, given the fact that a lot of people aren't able to pay their rent? What can a landowner do?
Well, and that's, obviously, like what I had mentioned earlier, is trying to establish some type of agreement where the tenant can be able to afford to make some payments back. We have available on our website, we refer to as our COVID-19 resource page. And so there are some best practices and some guidance documents that are provided to us by the National Apartment Association of saying, all right, look what's within your community, what is available that might be available at the county or the city level. See what other programs that might be available through me, and if there's any private organizations that might have anything like that. There's also they can contact us as well. And so, there was an article yesterday that was posted in the Press Enterprise about, some possible things that landlords could do. And some of them are quite extreme, but basically it's, trying to contact their mortgage lender as well. Perhaps there could be also some forbearance programs that can help them at least, delay making those mortgage payments. As well, there are also maybe also even provide any rental assistance programs that might be available to their tenants, sharing the information, and if their tenants do qualify, then that's rental income that can be going directly to the landlord themselves. And in terms of the national level, we're advocating for Congress to try to implement some type of nationwide rental assistance system. How that happened, we'll wait and see the details. But at least it's also in terms of our membership, also communicating with our elected officials to say, we need help, and here's some suggestions of how to go about it. Here's what we need immediately.
Thank you. My next question is for you, and I'd like to ask you, from a council member's point of view, what advice would you give to tenants in the city of Palm Desert moving forward, particularly with, of course, all of the issues that COVID-19 has brought up? If there was a piece of advice that you could give, what advice would that be?
I would say and I would assume that our residents of Palm Desert are well aware of this now because of the reaction they'll get when they call City Hall. To look at our website or to call City Hall usually will give them direction for almost any question they've had or are having about their rent or anything that's broken around their place or can't pay the rent or any issues that are coming up. We usually give them direction, or actually on our website right now, there are a lot of instructions. I think this is going to be a really valuable tool for them also to be able to watch this, because I've already learned a lot. I really appreciate the complete definition of the AB, AB 3088 that Mr. Walling gave us. Very, very detailed. So this is going to be very educational for people that are having questions as well. But we really pride ourselves on our website with links for assistance. Like I said, we focus on education. Here's what you can do to help yourself, and we're here to be of service. Does that answer your question?
Absolutely, it does. Thank you very much. Richard, I'm going to move over to you, and because I know at the Fair Housing Council of Riverside County, there's a lot of complaints that come in regards to repairs, and the timelines around repairs have been somewhat lengthy during COVID-19. What is the typical time period required for a landlord to conduct repairs on a property?
Typically, if it's not a emergency situation, they would have at least 30 days to respond to a request for service. And a lot of times, there are some landlords that just are not responsive, and not responsive in particular with with phone calls, emails, text messages. So we always advise our callers, and it's a little bit of extra work for them, but it does get a time period documentation in, and that is to actually put their complaint in writing, send it via certified mail, and then there is a 30-day period that needs to be responded to. And if they don't do that, there are not a lot of remedies available, and some are possibly risky for the tenant. But the bottom line is that things need to be fixed. And the other situation, of course, now under COVID-19 is that sometimes they'll use the excuse, well, we can't enter your home at this time because of restrictions, and that is that is an example, but there are CDC guidelines that will allow them to come in if they're properly masked and covered and sanitized to take care of a situation. So that really is an excuse, and of course the tenant would have to make sure that that they protect their family members that are there if there is a maintenance person that has to come in under the proper health guidelines. So yes, it's a 30-day period. If they still don't get a situation resolved, or if it's an emergency situation, one of the options that's available is what we call repair and deduct. But that is dangerous because that requires the tenant paying for the repair themselves and then deducting it from their rent. If they choose this option, they really do need to, again, get that to the landlord in writing. And if there is a dispute on that, it could possibly lead to eviction down the line. And I can let Carl kind of give a little bit more clarification as to how a repair and deduct could be of danger, but that is an option. And we had a call in yesterday where an air conditioner out in the desert, it wasn't in the city of Palm Desert, but very close by, was not working, and the health of the tenant and their mother were at risk. And we said that yes, it may be repair and deduct may be your best option at this point, about $750 to do the repair, and the landlord was dragging their feet on it. So it's a problem, but that may be the only option. And Carl, if you can maybe tack in on that answer.
Sure. So getting a little feedback there. Okay. So repair and deduct and other remedies found under the civil code for tenants can be very risky. I would highly recommend consulting an attorney before utilizing them. They can oftentimes result in you going through the unlawful detainer or eviction process, which is not a fun or pleasant process. I would know. I've been involved in many of them over the last 7 years. Very seldom is the repair and deduct done to a level that the local courts are going to believe was proper, and that oftentimes results in an unlawful detainer or eviction happening, even where the tenant, probably rightly so, feels resolute and firm that they did the right thing. So be extremely careful with any of these remedies. Please consult an attorney, weigh the pros and cons after being informed by an attorney before utilizing these remedies that put you at potential risk. Doing anything except paying the full amount of rent is always going to risk the unlawful detainer process. The unlawful detainer process does not allow for counterclaims. If you are a tenant in the unlawful detainer process, you can only go back to the status quo, go back to the way things were, or lose. There's no winning. There's nothing to win. You're not going to get money out of the unlawful detainer process. You're not, the landlord's not going to suffer a negative consequence as a result of the unlawful detainer process. Only you serve to lose through the unlawful detainer process. It's not someplace you want to be if you can avoid it.
Thank you, Mike. I'm sorry, Carl. I'm gonna move over to Mike because I know that he needs to drop off a little bit. So I'm gonna give my next question to him. What is your association requesting from the U.S. representatives and senators? What kind of legislation are you trying to seek during this time?
Well, so our point of view is right now, so there has been a lot of actions, whether it's down at the local level, county, city, federal level, to basically put in stopgaps to protect tenants in the most part. And so our position is that that's great and that's fine. We understand that, but also there should be things in place, whether it's through programs, through financial assistance, or some other type of assistance to provide to landlords as well, who are also being affected by this crisis. And so right now, Congress, the House is now in negotiations with the administration in terms of a stimulus package. And one of the things that we're telling our members now to contact your member of Congress and say, please try to enact some type of nationwide or some type of assistance program that can be applied to every state. And that could be along the lines of similar to the assistance programs that you see here in Riverside County. County of San Diego also has just recently unveiled their rental assistance program for those tenants who qualify. And if they decide to include other things such as unemployment benefits, increasing the payments for that, that's fine. Basically, it's whatever helps the tenant be able to continue making the rental payments so they can avoid the burden of having to make up all those missed payments later on down the line.
Susan, a question for you, and hopefully you'll be able to answer this. The city of Palm Desert have any programs that are in place specifically for property owners to help them make repairs on properties they rent out? If they don't have the funds to make those repairs, are there any programs available or any resources that you can guide those Palm Desert property owners to for assistance?
So actually, my name is Susan Marie, not just Susan. And you're saying, do we have programs in place in the city of Palm Desert to help property owners make repairs as necessary?
If there are any services or programs that they can go to.
I can't think of any off the top of my head. I would be just like everybody else. I would go look online to the city of Palm Desert and see if there's something that helps property owners. Mostly the questions that we have pertaining to renters having their questions. But property owners, if we were going to talk about emergency repairs of air conditioners, like you just said, we do have programs in place for that, and that might benefit a property owner if all of a sudden the renter's air conditioner breaks and there is no money and the property owner has no money. We have emergency things in place for that. Also, we advise people to contact utilities, because utilities, Edison and the Southern California Gas Company, frequently have programs that help people fund these emergency repairs.
Thank you. That was exactly what I was looking for. I know that at the Fair Housing Council, we actually receive calls from property owners who are facing, just like you mentioned, broken air conditioners, and they just don't have the funds to repair it, and they're looking for resources. So that's very helpful. Thank you.
Yeah. And if I may mention from my previous employer, the Community Action Partnership of Riverside County, they have the weatherization program, which is available to low-income residents. And that's a program where they can go in and assess a home, see about replacing air conditioning, windows, insulation, and to make the home more energy efficient. And so that's one of the resources that we also refer clients to that have that type of a need.
Right, and I just like to jump in with that as well. So, San Diego Gas and Electric, they have similar programs for both for multifamily and single-family property owners as well. Again, weatherization programs, also maybe also to assist them perhaps with some of the issues such as air conditioning, and also there is also, and I can't name them off the top of my head, but like the City of San Diego, the San Diego Housing Commission, the San Diego County Housing Authority, they have similar programs for lower income property owners that if they're having an issue with their property and they need assistance, there's programs that will be available to help them to be able to defer the cost. But one thing that we always tell our landlords is make sure that you have a reserve for every property that you have, to be prepared for those those rainy days. That so in the case that something does happen, you have your own you have the finances in place so you can make those type of repairs if needed.
Thank you. Carl, going to move back a little bit to AB 3088.
Okay.
One of the issues that we are seeing at the Fair Housing Council Riverside County are property owners who are contacting their tenants and telling them that they're selling their home and that they have to vacate. And of course, during the COVID-19 pandemic, it's difficult sometimes to locate a place to live. Under AB 3088, what is this allowed right now for a property owner to just say, I don't want to rent anymore and you must vacate? How does that work under the 3088?
The short answer is sadly, maybe. It is a legal gray area, as I noted earlier in 3088. You do need cause to evict currently. However, there is one category of cause where it is called no fault just cause, where no fault of the tenant. The tenant could be the most perfect, ideal tenant you can imagine in your head, and they can still get evicted for no fault cause evictions. Several of the no fault cause evictions may encompass what you just said. They are as follows, essentially. One of them is removing the rental unit from the rental market. If the unit is being removed from the rental market, that is deemed a no fault just cause and can be a basis for eviction even under AB 3088. Proper 30 or 60-day notice would likely be the recourse. In addition to this no fault just cause basis, there would also be selling the home to a new owner who intends to reside in that property as his principal residence. Those would be two no fault just cause exceptions to the normal rule, and therefore they would allow for an eviction potentially under this scenario. If a tenant is looking into fighting this, they should do a deep dive and see if these things are actually the case. They should perhaps utilize discovery in their case to determine if they are a real reason for the eviction. But if they are, yeah, it could very well be a valid reason under AB 3088. Please keep in mind that if you are evicted under a no fault just cause reason, you are entitled to 1 month's relocation, which should be paid to the tenant or provided to the tenant in the form of 1 month's waiver. If this is not provided, it would result in a defective eviction and a complete defense to that eviction. So that will help pad the blow if a tenant is being evicted under that basis.
Thank you. And Mike, what kind of guidance are you giving your members in terms of when they do want to sell their properties and how that would affect current tenants?
Well, so I mean, we always inform our members of, so we have one particular form to let them know that if you're considering selling your property and you're going to go about that you should provide them at least 120 days notice in advance that you intend to sell that property. When they're considering that, we let our landlords know, it's like, okay, well, if you're selling the property, and I don't want to say it would be nice if they can try to be able to find a prospective buyer that may want to keep that property as a rental property, but we just tell them to just be aware, of that. Yeah, you'll be responsible for the relocation assistance, and that And that, if you can, just because you're selling the property does not mean you have to evict the tenant. So we try to, we try to tell them to, try to avoid that recourse and leave it up to the hands of the new buyer, if possible. And I apologize. I'm gonna have to leave out, so I have another meeting right after this.
Well, I appreciate you joining us, and I know that the information you provided is very valuable. So thank you for joining us this morning.
Yeah, thank you very much. And also, if you have more questions, please go to our webpage at www.socal.rha.org. Thank you.
All right. Thank you, Mike.
Bye. Thank you, everybody.
Richard, can a landlord turn off somebody's power or lock them out if they want to, if they're not getting paid and they say it's my property? Can I just change the locks on my house or turn off the power?
Absolutely not. That is that is not legal, and when we get a call like that, you can call the police. I mean, that's the remedy, because that is unacceptable.
So Carl, in the second line of questioning, one of the areas that we are seeing an increase in is individuals who are renting rooms. So they're not renting an apartment, they're renting a room. And particularly when the COVID-19 pandemic hit, they would leave the property to go to the store and come back and find themselves locked out. And a few of them did call the police and they still could not get in. So how does that work with just a roommate? I know they have certain exemptions there, but what are their rights?
By and large, for the most part and in most circumstances, if you're renting a room, you have the same rights as we've been discussing in regards to every other tenant. There are some very small exceptions that I'm not sure many people in this state know how they would even work in light of the new AB 3088 changes, which appear to apply to everyone except for perhaps transient hotel occupants who may be accepted from these new rules. So you should be entitled to the same protections. Now, we usually encourage tenants who undergo a situation like you just mentioned to call the police, because that is likely, if they're going to receive immediate relief, that's likely where they're going to receive it. Because any of their legal remedies, while they're probably entitled to some, they're probably entitled to some significant civil penalties against the landlord who did this to them, which have been increased now under AB 3088, even higher than they were before. But all of those remedies take time, too much time. They probably take months, whereas the tenant needs to know what they're doing now. They need to know, where can I go? Can I go back? That remedy and those answers are going to be found with the police first and foremost. Unfortunately, the police are not usually excited to get involved in these matters. Their usual refrain is to call it a civil issue and tell you that you need to sue. But these can be a potential criminal matter, and I would encourage those who are receiving this response to go higher up the chain of command with the police, and usually one of the first things we recommend is, if they get this response, to contact the watch commander, who's generally a bit more familiar with the law and procedure than perhaps one of the normal patrolmen.
Okay. In regards to we're going to kind of talk about repairs a little bit, because this has come up, and I know we touched on it just a little bit, but I'd like to go a little bit deeper. When we are talking about repairs needing to be done, one of the excuses that we are getting from landlords is, well, we can't enter into the individual's properties to make the repairs because of COVID-19. Is that a justifiable reason to not make the repairs?
No, as I had mentioned before, there are precautions that can be taken in order to make the repair. Especially if it is a essential a problem that needs to be dealt with immediately. so, you know, as long as there are proper precautions, health precautions taken, and that the tenant is able to also protect themselves if there is entry, and you know, and not permit entry unless the repair person is properly masked, you know, and gloved, probably with sanitizer. Sanitize everything that they have touched at the time that, you know, they're doing that repair, and you know, certainly not going off of any other path other than to make the repair. Then yes, if it's a necessary repair, then it can be done under the proper precautions. It should be done.
If I may add, there are sort of two legal sides to this, and even if you're a tenant, you should know both sides. First and foremost, Richard is certainly correct when he says the duty to repair is still there, and he properly pointed out that California typically construes the reasonable time to make that repair as 30 days. That's still there. That hasn't gone anywhere. There's been no legislation under California that has changed that duty to make those repairs. However, there's a simultaneous duty of the tenant to allow the landlord entry into the property after the landlord gives proper notice of entry, which is typically written notice given at least 24 hours in advance with a proper reason. One proper reason is making repairs. So I would caution tenants into denying landlord an entry, because that is a specified at fault just cause basis under AB 3088 to evict. If you're not allowing your landlord in to make repairs, that is denying a potentially lawful entry if the landlord gives proper notice, and you could be serving your landlord on a platter a valid reason to evict you.
I think that's a very important distinction, and something that I believe people definitely need to keep in mind and remember. I know that the general understanding of AB 3088 is that it protects everybody from evictions, but as you continuously are pointing out, there are things that can be done. And I know that one of the areas that I've been concerned with in terms of AB 3088 is the potential for increased discriminatory treatment as a way to evict. So I cannot evict my tenant because they're not paying rent. So I'm going to come up with some of these other things. And I believe the other day you and I were talking, and you were discussing the fact that within the bill, it was thought about or addressed how to deal with that potential. Could you take a few minutes and talk about that?
Yes, so AB 3088 has actually increased retaliation penalties and has specified that retaliation can be in the form of a pretextual eviction. Now that sounds really fancy. What on earth does that mean? A pretextual eviction is essentially an eviction for one stated reason, but they're actually evicting on another. Typically, this would be found in the instance of a tenant not paying their rent, properly submitting the declaration that we discussed earlier, and a landlord getting creative and coming up with another just cause basis for eviction. This has been specified in AB 3088 as potential retaliation and has increased the remedy if a tenant is to be able to prove retaliation occurred, the amount of damages that they'd be able to get if they were able to do that.
Thank you, Carl. Richard, talking about discrimination, how, when a person calls in, particularly when they call Fair Housing Council Riverside County, 90%, as you stated, are repair issues. How does Fair Housing Council go about identifying cases of discriminatory treatment, or what does a person need to do to recognize it?
Well, of course, everyone is protected in the Fair Housing Act under the protected classes, and we know the 7 federal that I mentioned, and of course in the state of California. And our counselors are all aware of those different classes. So part of the pre-qualification that we do is to take information from every caller, because we have to document these, every caller that we have and report it to our funding sources. but that's how we can at least determine what the situation of a household is. And so with that, knowing that there are children present, knowing that there are people with disabilities present, knowing, of course, the male, female, knowing the income levels that we have to ask these questions for, and the racial and national origin questions. We know then the profile of the person that we're serving, and so that's one of the reasons that we ask these questions, is so that we know who we are serving. And when an issue comes up, then, and a lot of times, the people just are complaining about non-responsive landlords, but asking further questions about it, exactly what is the nature of their non-response, how are they responding, and sometimes they say, well, they send me a question or respond back and say, well, I don't want, why do you Mexicans do this? Something like that, or or we hear a response that, well, I heard that my neighbor said that that they don't do repairs for African Americans as quickly as they do for others. So these questions are not on the minds of the person when they're calling in, but in speaking further with them, our counselors are able to see if there is this pattern of discrimination, and that is often then the basis of why they're not getting the service. So it is through the probing of the counselors and the the pre-qualifications that we have in dealing with our callers that we are able to identify discrimination and then move forward to remedy the situation.
We talked about the fact that sexual discrimination, sexual harassment has increased. And I know working in fair housing, I know that the complaints that we get are just the tip of the iceberg. What is the requirement of somebody to prove that they are being sexually harassed? Do they have to prove it in order to file a complaint?
They have to have it's based on how they perceive their treatment that they've received, that they are receiving. So there may not be, quote, a smoking gun of this, but it's just the course of action that has caused them to feel this way. So when they fill out a discrimination complaint to us, they also have the opportunity to have witnesses that may have also seen this, or that we would like to know who they've told about the incidents, and we then are able to do some further investigation to follow up on and collaborate some of the stories, because when we submit a case to HUD or to the state, the FEH, or to an attorney, we want to make sure that it's as strong a case as possible. And sometimes our investigation, we may not find that, but we do make those filings on behalf of the client if they wish to have that done for them.
Okay, thank you. Susan Marie of Palm Desert. I know you mentioned during your opening statement your affordable housing and the pride that the city of Palm Desert has in how you have set up that affordable housing. Are there any projects in the future or in the talks of to increase the number of affordable housing in Palm Desert?
Yes, we're constantly working to bring more housing to the city of Palm Desert. Some of them have made the newspapers when we were bringing in the Sands that was going to be building affordable housing over by Carter School on Hoveley. Also, we're working with many developers that come in and talk with us all the time about how we can set up more affordable housing. So we are, yes, working on it all the time because housing is really important. We especially like it when people who work here in Palm Desert can afford to live here in Palm Desert.
In terms of the residents of Palm Desert, what can they do to help assist Palm Desert in that endeavor? Because it's always about community. So what can the community do to help?
Well, we like it when we have a developer coming in with this affordable housing. We like to set up show and tell We like our developers to explain to the community that is going to be around that housing complex how it's going to affect them. Because a lot of people, as you know that phrase, not in my backyard, not in my backyard. So education is what it's all about. What's the developer bringing to the city? What will the housing do to help our city? And how will the residents be impacted by it? So it's mostly about education. And so we appreciate it when our community members participate when we have those educational forums to just kind of let everybody know what's going on in the city of Palm Desert.
And how can Fair Housing Council of Riverside County help the city of Palm Desert?
Question. Well, as you know, we partner with them all the time. They're on our speed dial. When people have questions, we send them over for that, for specific instructions. That has been of great benefit to the city of Palm Desert to deal with that. In fact, I think we were going to have a complex, one of the complexes I think we were looking at was going to be built by Fair Housing at that time. Julie Bornstein was working with us on that. So as you know, in government, everything takes 1,000 years. So we're still working on all of that.
Absolutely. Thank you very much. We're going to move back over to Carl. And I want to talk a little bit more about a property owner who's selling their property. I know we talked about repairs, but we do get quite a few calls on a daily basis where a tenant calls and says that not only is the property owner trying to sell the property, but they're showing the property and there's all these people walking through the house. What guidelines should a real estate agent follow that protects the tenants of the property that's being sold?
Sure thing. So a landlord is allowed to showcase a property that is being sold, but it would require that 24-hour, at least 24-hour written notice in advance. That could be a potential basis under the law that allows a landlord to do that. If these notices are not being given, then your rights are not being upheld. With that said, it would be inadvisable to prevent the landlord from showcasing it if proper notice was given, because again, that could be a basis for an eviction, even under current AB 3088 law. If you fail to deny the landlord entry when he is allowed to do so by law, that is just cause basis to evict. From the perspective on both sides, anybody who is seeking to showcase the property should be providing the proper notice to the tenant in advance, at least 24 hours written notice, properly served, with the reason stated on the notice for the entry. Likewise, if after receiving that notice and the proper time has passed, the tenant should allow the entry because it is arguably a lawful one.
Beautiful. So I'm going to go ahead and I'm going to check the question and answer panel. I'd like to remind the attendees that are on the line, if you have any specific questions, please feel free to enter that question into the question and answer box. We'll give that just a minute to see if any questions come in. There's currently no questions in the queue. I'd also like to remind the panelists that this is being recorded for future broadcast and will be available by either Monday or Tuesday, at which time it will be shared to the general public and those individuals that were not able to attend live today. I realize that sometimes it's difficult to attend a meeting at 10 o'clock in the morning during the work days. So that's why we're doing it both recorded and live. Okay, so a question did just come in, and I will, the question states, what happens if the landlord is selling the house, notifies tenant, and when the showing occurs, the property is a mess, inhibiting the sale? Is that considered sabotage, and what can a landlord do?
Great question. There may be some civil liability, small claims liability, if the landlord can prove that there's been some, the fancy legal word for it, I suppose, would be tortious interference with contract or business transaction, etc. There are such claims that do exist under California law, may be difficult to prove. Um, Absent that remedy, I don't think there's much else that can be done, but that is something that could be possibly examined in a scenario like that.
Thank you, Carl. Okay, are there any other questions from the attendees? All right, since there are no further questions, I would like to remind everybody, including those that are listening to this on a future broadcast, if you do have any questions for any of our panelists, feel free to email Fair Housing Council Riverside County, and we will get those questions to the panelists to try and get those answers for you. At this time, I would like to go ahead and move into our closing statements and any advice or anything that you would like to say to the residents of Palm Desert as we close out this morning's session. And I'm going to go in reverse order from our opening statements. So I'll begin first with you, Carl.
All right. First, thanks for having me. Thank you for inviting me. Thank you for inviting Inland County's Legal Services to be a part of this. Thank you all attendees for being here. We appreciate you. If I were to bottle everything up that I would want said into a few points, it would be this. If you can continue paying your rental obligations, you probably should. While protections exist, these protections are limited and may eventually result in eviction, albeit a delayed one. It might buy you some months' time, but when those months are gone, you're not going to like the place you're in. So if you need these remedies, though, you should use them. And if you're going to use these remedies, you need to know your rights so that you can do it properly. If you do it properly, you lower your risk. So you should know your rights. You should know about the declaration. You should read it carefully, make sure it applies. And if it does, and if you need it, use it. And then make sure that you pay your 25% of the rent before the end of January so that you get your enhanced protections from February and beyond and do not find yourself being evicted on that basis. Lastly, just know that you're entitled to cause to evict right now.
Thank you, Carl. And Council Member Susan Marie, your closing statements are something you would like the residents of Palm Desert to know, your takeaway.
Well, of course, in keeping with the city of Palm Desert, we aim to educate. Whenever anybody goes to our website, or if they have difficulty finding the drop down or any difficulty at all finding help from that website, if you call the city of Palm Desert, we're able to direct you immediately to the agency that will be able to give them assistance. And one thing nice about this forum today, now they can see all the faces of the people that they'll be talking to that will help them. And I really appreciate that very, very much. So we might not know all the answers at our fingertip, but we definitely know where they can go to get assistance. And so I appreciate all of you today, and thank you very much for setting up this forum. Thank you.
Thank you. And Richard, your closing statements, final advice you would like to give the residents of Palm Desert. The floor is yours.
Oh, thank you. And one of the last things that I was able to do in person before the great shutdown in March was attend the Palm Desert's crime-free meeting about a week before the shutdown, and met with several of your apartment managers there, and the Sheriff's Department, the Palm Desert Police, and it was very, very beneficial to get to meet and talk and interact and share information on fair housing. They're very, very interested in that. And I know the residents of Palm Desert, we get plenty calls from the city. And it's always a pleasure to be able to serve them with the answers and the resources that we have to offer. So just the big takeaway is, please, we are available. Fair Housing Council Riverside County answers our phones live. We don't have an automated system. We have counselors that pick up the lines in 3 different offices, and you will be assisted by a live person, and we will try to get the answers to you. We do a lot of referring to Inland County Legal Services, and we certainly appreciate that. wonderful, wonderful asset that that we have in Riverside County, because you know, we're not attorneys. We you know, we can't give legal advice, and they do an excellent job for us. And to refer things also, you know, to other entities in the city. The city is always responsive. So please always feel free to call us and contact us, and we're happy to serve.
Thank you, Richard. And as far as my closing comments go, what I'd like to do is thank each of our panelists for taking the time to attend this morning to share this valuable information. And Richard pointed this out very well. This is about partnerships. It's about working together. And I believe that doing events like this helps to put names and faces to the programs that are available and lets everybody know that you're not alone. And my biggest takeaway through this, through COVID-19 or post and pre, is you're not alone. There's always help, there's assistance, one phone call away. If one agency can't help you, they're going to refer you to another, but there is somebody that can help. And I'd like to thank everybody for your attendance today. I hope you have found this information to be valuable. And remember that, you know, we are here to assist you. We are here to provide that information. And I wish everybody a very blessed day and a blessed week. And thank you very much.